Okay, we are live, Judge Maderi.
Okay, awesome. Thank you. All right, guys. Good morning. Welcome to TIDC's December board meeting. It's our final meeting of 2025. Obviously, you can tell I am not in person, and I had to unfortunately join you all remotely because last Sunday I very badly sprained my ankle. Now, I'd like to say to you, that I was doing something really, wild or outrageous, like skydiving or bungee jumping, or even like running a marathon. But instead, I just would like to say that I stood up, my foot was asleep, and boom, I went down. So not anything wild or crazy. But then I did get a text that afternoon from Scott, and he told me that Judge Shank had broken his ankle. So I don't know if you're trying to get out of a TIDC meeting, but if you need to in the future, go ahead and you'll have to sprain or break your ankle. So I don't know if Judge Shank is with us, but I want to tell him I know how he feels and I hope he feels better soon. So before I go on, I'd like to say I'm going to turn the meeting over to Jim because it's difficult to lead a TIDC meeting from remotely. So Jim and Scott and I have been meeting constantly this week to kind of go over a few things, so that Jim was going to lead it. Before I turn it over to him, I do want to say thank you to some staff for their service to TIDC. We're starting back up with the service awards to TIDC staff. And the following staff will be getting gifts from the Capital Gift Shop for their service. So for serving, and please, thank them for serving 5 to 10 years, is Megan Bradbury, Doriana Torres, and Scott Ellers. For serving 10 to 15 years, we have Deborah Stewart and Edwin Colfax. For serving 15 to 20 years, Joel Lawrence. And serving over 20 years would be Wesley Shackelford. So I don't know what the gift shop will give you. Hopefully at 20 years, Wesley, you can get like a good keychain or something. Okay. Anyway, thank you all very much for your service to TIDC. We all appreciate you. Yeah, thank you very much. Give yourselves a round of applause since we're not there. Awesome. All right. And now, Jim, I'm going to turn this right on over to you. Okay. Thank you all. I'm going to put myself on mute, but I'll be here.
Thank you, Judge. Do you want to call roll?
Sure will. The Honorable Missy Maderi.
I'm here.
Mr. Jim Buskey.
Here.
The Honorable Jimmy Blacklock. Mr. Alex Bunnan.
Here.
Mr. Jay Cohen. The Honorable Valerie Colby. I do see that she is here. I'll come back when we can hear her. The Honorable Brennan Creighton. The Honorable Richard Evans.
Here.
The Honorable Emily Miskell.
Here.
The Honorable Joe Moody. Honorable David Shank. The Honorable John Smithy. The Honorable James Woolley.
Here.
We have quorum.
There's 3 people in the waiting
You're
room.
not.
Okay, I got you.
Next, Scott, Director Fruitman.
All right, thank you.
Minutes. Yeah. Everybody had an opportunity to review the minutes. Changes, motion,
So moved.
you're gonna, all in favor? Or who's gonna, oh yeah, I'll say go ahead and second. All in favor, say aye.
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 Thank you, Jim. Director's report. We have some new hires that I wanted to introduce y'all to. Rhonda Reichen to my right. Rhonda joined us on November 14th as a senior policy analyst. She's going to be working with Crystal on family protection representation projects prior to joining TIDC. Rhonda was at the Dallas County Public Defender's Office for 13 years, representing children and parents in child protective services cases, and prior to that, 12 years in private practice. Welcome, Rhonda, to TIDC. We also have Jim Wilson with us, who joined us yesterday. So Jim is our newest grant specialist. Jim was a regional county program administrator at the Texas Juvenile Justice Department for nearly 8 years. And so welcome, Jim. He's going to bring a lot of expertise on grant matters. And we're welcoming both of you. Thanks for joining us. We're very excited to have y'all. We have a Title IV job posting that has been closed. We have candidates that we will begin interviewing hopefully next week. Cody Huffman, wanted to congratulate him for a law review article he had published in The Scholar, a St. Mary's law review. And Ashley De La Garza has been invited to join Gideon's Promise National Faculty. So congratulations, Ashley. Quick legislative update. You may be aware that in November, Texas voters approved Proposition 3 or SJR 5, which was a constitutional amendment requiring judges to deny bail for certain offenses. And so that amendment included a provision that says at a hearing described by this section, a person is entitled to be represented by counsel. And so during the policies and standards section, Wesley will go into a bit on our plans to develop policy monitoring protocols around this provision, new provision in the Texas Constitution. SB 9 was passed by the legislature this past session, which allows prosecutors to appeal bail amounts that they view are too low in certain serious offenses. And so the Texas Supreme Court promulgated some provisional rules around this new law and the appeals process. And they took comments, and that closed on December 1st. And so we will see how the final rules turn out and see, we will have to determine whether our policy monitoring processes need to change in regards to those rules as well. Recent activities, Indigent Defense Workshop in October, thought it was very successful. We had 83 attendees from 27 counties across Texas. And folks seem to be, from our evaluation, they were interested in starting a regional public defender office, family protection representation funding, and the legislative updates. Dr. Gamble, Kristen Meeks, and I attended and presented at the Indigent Defense Research Association last month. We have some new publications out. We have a county stakeholder manual for new counties that are starting up public defender offices. We have our Texas Fair Defense Laws, 2025-2027, updated after this past legislative session. Operation Lone Star, arrests continue to be down. As mentioned last meeting, magistration is now occurring locally, and detention of OLS arrestees is also occurring locally. There is no longer any central magistration, and new arrestees are not going to the Briscoe and Segovia units any longer. And as you may recall, we established some new grant provisions allowing for those local counties to come to us to seek reimbursement for their OLS related indigent defense costs. And so Linda Gonzalez, our OLS senior policy analyst, reached out to all the counties along the border to let them know, remind them about that grant program. We did not receive any new grant proposals under that, but we will continue to remind the counties on ways in which they can seek reimbursement for us. And then finally on OLS, we continue to work with LPDO in regards to reviewing their financial records for the OLS grant and the outstanding balance there. And Lubbock County's formula grant is on hold during this review process. And once that is completed, we will reach out to Lubbock County and LPDO to let them know about our findings. That is all that I have. I believe we can turn things over to Dr. Gamble.
Do we have any comments or questions regarding Scott's report? I'm gonna go ahead and just say one or two things, but in reference to the workshop, it was absolutely outstanding. Staff did an incredible job. The folks that I had attend are already working on some of the things in which they learned. So, on behalf of Bear County, I just wanted to say thank you. Dr. Gamble.
Thank you. Good morning. I'm going to start my portion on page 19. I have 4 things to discuss. The first is we finalized our survey to attorneys throughout the state. It's the Indigent Defense Attorneys Motivation and Perceptions Survey. We asked several questions to attorneys trying to understand what got them into the work, what is motivating them to stay in the work, and what is possibly having them motivated to leave the work. We had a great response. We had almost 500 attorneys from the state respond. 410 of them have are active in the work. They've taken cases in the past 12 months. Only 34 have stopped or temporarily paused cases. That might be the only thing that we should improve upon in the future, but great responses. We had over 50% of the folks that responded were solo practitioners. 30% of them were employed by public defense offices, and these are the graphics on page 19, and you can see those breakdowns. I know the text is small. Moving to page 20, if you look at the respondents to the survey, the majority of them spent half or more of their time, so we're gonna get good feedback from folks that are very active in the work. We're also going to get good feedback from folks, that do the work over the different, types that we have, adult criminal defense, juvenile delinquency, and family protection. This distribution of responses is very much the same as our distribution of practice time when attorneys report, so that's good news. And now, additionally, we have 22 folks from this survey that volunteered to have qualitative interviews with us that we will be doing starting actually on Monday. We'll start interviewing attorneys from the state, trying to just dig in a little more. And that those surveys will be conducted by myself, Kenitra Brown, and Linda Gonzalez. So my thanks to them. Next, just of note, we are still moving forward on a family protection representation research with the Public Policy Research Institute, looking at the economics, trying to understand average costs around family protection cases. So we look forward to that starting in 2026. Next, on page 21, a brief data website update. The data website has been collecting information from counties for the attorney practice time reports, the indigent defense expenditure reports, and the family protection representation plans on the new website with the website noted there. And folks will tell you more about those, how that's been going in their sections. We did have to leave the adult criminal and juvenile delinquency plans on the legacy website. And so that is continuing to take submissions, and the policy team will talk about that as well. The Public Policy Research Institute, who is in charge of building and maintaining the website for us, they have increased the number of full-time staff that are going to be focused on developing this website. It's gone up to 3 full-time staff that we'll see starting to work with us in the new year. Several reports are available, and I've put the website here for counties, for folks, for fans of data to start looking at, noted on page 21. Now moving to page 22, turning the page a bit. This is the caseload standards work group. So at the last board meeting, and I think the board meeting before that, the board talked we've had several conversations about caseloads. The last meeting, the board passed a motion to amend contract offender rules to require counties with a contract offender program of 1 week or less in duration to establish maximum annual appointed caseload limits for attorneys in the county's indigent defense plan. The board directed staff to conduct research, and we have a proposal to start a work group around this. In response, we would like to have the work group provide guidance to the board regarding how TIDC should evaluate which counties and attorneys have caseloads that exceed TIDC's caseload guidelines and the impact of excessive caseloads, determine what factors are driving attorney caseloads to exceed TIDC caseload guidelines, collect additional data, information, and understand hindrances to managing or limiting caseloads, and determine whether a rule establishing caseloads is advisable, and proposed language. So we set up, for those of you who were around for the salary work group, have set this work group up very similarly. We would like to determine what additional information the board needs and the work group needs to make decisions. And so our timeline on page 23 is that we'd like to have an initial meeting in February of 2026. No date has been selected yet, but we would like to work with the board, with the chairs on selecting a date for the meeting, as well as potential members. And roughly, we'd like to have results back to the board for the December 2026 to make any decisions.
Yeah,
And
on that, if I can cut in real
Yeah.
quick, if any board members have suggestions on folks that they would like to be on the caseload standards work group, feel free to let me know, send me an email or Dr. Gamma an email, and we'll make sure to put them on the work group.
And I will just make a note, we are always looking for a good representation throughout the state. So even if your friends in smaller counties, that would be a good members of this work group. We look forward to your input on this, and we'll work with Judge Madarian and Mr. Bethke on finalizing the members and the dates. Last thing, maybe I'll pause. Any questions about that work group? Wesley, this is a collaborative project working with Wesley and Scott. Did I miss anything?
No, I think so.
Okay. All right, the last thing, I'm working on modernizing the policy monitoring tools. The policy monitoring team has several tools that they use regularly for their visits, and so I'm just reviewing their court observations, their interview methodology, and trying to put this into a web-based data collection system that will help these teams not only process quicker, their findings, but have us collect information more consistently throughout the state. This will be in Qualtrics. And the areas that we are working on are the court observation survey, the judge interviews, the indigent defense coordinator interviews, court coordinator and court staff interviews, and attorney interviews. And I'm working with Ashley De La Garza and the policy monitoring team closely on this, and excited about this project. Any questions?
Excellent report. Moving on to family protection and representation. Kristen.
Thank you. Good morning, everyone. So on page 25 is where you can find the Family Protection Representation Report in the board book. We have a list of our different committee work and presentations. I won't go through all of them there, but you can see them on page 25. We are collecting the Indigent Defense Expenditure Report for FY25. This is on the new website. And as of the writing of this report, which was back on November 17th, we had 214 counties enter information on the report, and of those 214, 192 had fully submitted. We do have some work to do to get people to finish these up, and that's something I think Rhonda and I will be working on later this month to get people to finish this up. Especially as we go into preparation for another legislative session, this information will be really important and we want to get it in quickly. The preliminary reported spending, I will note this will probably change once we're done with all of the reviews. It's just over $66 million, which is an increase from reported spending from last year. So we'll see how everything shakes out once we're finished with our full reviews and everything. One thing to note, we will be making the attorney detail report for family protection mandatory next year. We had this optional last year and this year. So this is done on the criminal side. It's been done for a long time. The attorney level detail report shows how much each individual attorney is paid each year. We don't have that, excuse me, for family protection yet. We think it'll be really important and helpful to learn this information. We've given the counties 2 years now to try it out, practice. We made it very clear in our training and the IDR manual that next year it will be mandatory. So next year everyone's gonna have to do it. That'll be a fun exercise, but we're gonna get there, and I think we'll get some really good information. And moving on to page 26. We are also collecting plans this year. Plans are due every other year in odd numbered years, so we're getting our 3rd year of family protection plans. These were done on the new website as well. So moving people from different websites was a little bit of a challenge, but we're gonna get there. We do have some work to get more counties to get their plans in. When I wrote this report, we only had 100 counties having fully submitted their plans, so quite a few needed to get it done. And again, in the next few weeks, Rhonda and I are gonna start making phone calls and emails and getting people to finish that up. We did finish our FY24 data report. For those of you listening online, that was attached in the last email, so you have a PDF of that. Those of you here in the meeting, you have a copy of it. It looks like this. I have a little picture of the cover in the board book. For those of you that really love Family Rep, you can read and dig in. I think it's a lot of really helpful information. I think learning about how we spend money tells us a lot about what's going on out in our state. But some things of note, the final total spending was just over $62 million, which is fairly consistent with the previous 2 years. It's a little less than the year before, but not significant. Statewide per capita spending is not very high. It's only $2.02 on family representation. And then when we break down the counties and look at each individual county per capita spending, it goes from 4 cents to all the way to $16.96. So the range is quite large. The other thing of note, and I think this is something that we should really be thinking about as we move forward with this work, is that when looking at the spending breakdown of the counties, we have 155 counties that only spend $100,000 or less on family protection work. So that's over half of our counties. And they only contribute 8% of total spending. So that's a significant amount of counties that are giving a very little piece of the total pie. Some of those counties are legitimately very small, and I don't expect them to spend a lot. But there are some in that group that should definitely be spending more given their volume of kids in their counties. So that's something we should really be thinking about. And then we do get attorney practice time data every year. That's also very helpful. Dr. Gamble did some really helpful work on that and compared the bar licensure, the bar numbers of people who submitted their report. We got just over 1,000 people submit a report, so a pretty decent sample, compared it with their bar year date. And we have, and you'll see the graph in the report if you look at it, but there's a steep decline once you hit the last 10 years of bar licensure. So that's another thing we really need to consider, is we don't have a lot of people licensed in the last 10 years that are doing this work. We need to fix that because, people aren't going to do this forever that have been doing it for 30 years. Title IV-E, we're making some good progress. As Scott mentioned, we do have a job opening right now. The job is closed. We've been reviewing applications. I really hope to interview before the end of the year and hopefully have an offer and maybe someone in here right as the year starts. That person will be fully dedicated to working on Title IV-E. So providing support to counties, education, technical assistance, collaborating with DFPS, and really just digging in because there's a lot of counties that are not accessing their funds. Some of them would be getting substantial amounts of money back and they're not. So we really need someone to do that. So I'm really excited about that. We've been working with DFPS pretty regularly. They did do a joint presentation with us at the ID workshop, just kind of a nuts and bolts, how to get your IV-E money. And we do meet with them regularly since our last meeting. So some progress there. It's not as fast as I would like, but it's a big project and we are working with DFPS on it. So it's not going to move super quick. We are doing a collaborative project with the Children's Commission. This is another exciting project. Dr. Gamble helped put together a survey on Qualtrics. And this is to get some information about pre-petition work. So pre-petition work is legal representation before a court case is filed. Now, rights to counsel are only triggered once a court case is filed, but in the child welfare space, there is a lot of discussion and interest in pre-petition work because tens of thousands of families go through the child welfare system before court is ever filed. Very significant and long-term things can happen to kids, like permanent separation from families. Maybe they end up in foster care. And so there's an idea that pre-petition work may help alleviate some of those significant consequences for families. But working with the Children's Commission, they've been very interested in this, but they realize that a lot of people have different thoughts on what pre-petition work is. So if they're going to put some effort into it, and we work very closely with them, they wanted to know, well, what are the thoughts out there? What do people even really think about this? We had a pretty good response. We had over 320 people respond to the survey. This was a mix, so it was judges, attorneys, caseworkers, all kinds of people that are in the child welfare space was who was targeted to do the survey. We did have over 100 people say their pre-petition work was not available in their area. 60% or 60 respondents just didn't know, so that was kind of interesting. Well over 150 people said that there was a need for this representation in their area. And 48 people said that funding would definitely be needed to make that project move forward. So something to think about as well. Hopefully someday when we get grant funding, perhaps we can braid some of this work into the things we're doing. So that's all I have for now.
Excellent report. Any comments or questions? I have just a couple quick comments. First, really thoughtful, well put together. Appreciated the breakout in the back of the report, county by county. So we had 243 counties that actually submitted a report and got approved. So there's only like 10 or so that.
Yeah, it was technically 244 had an approved report. One just never submitted anything. So that's, I mean, I guess that's not bad if only one did nothing. 9 we did not approve because we had tried to reach out about potential errors or issues and we just never got those resolved. So we did not end up approving those.
In one of the counties we'll be taking up in grants and reporting later, it may be an opportunity to fix something else that's quite possibly broken in Maverick County. But Maverick, I saw that they submitted, but it wasn't approved.
Mm-hmm.
So with the rural funds, I don't know if they have to apply, but I know they're through Trala, they're setting up the public defender. So children with that supplemental money to do something in reference to
Yeah, you know, ideally everybody would submit reports that we believe to be accurate because that helps us determine decisions we want to make, suggestions we want to make to the legislature. So it's really helpful. There's only 9 on the naughty list, but yeah, definitely, unfortunately, we weren't able to get all those people on board.
Excellent report.
Thank you.
Turning it over to grants and reporting. Edwin, Justice Miskell.
I'm sorry, just a second. There's a question in the comments from Valerie Covey, if someone wants to see that or get that.
Hi, guys. Yeah, I was just wondering, you know, we're dealing a lot in Williamson County on CPS matters, all things family, you know, courts and stuff like that. And just wondered if y'all are engaging CASA, the court of, you know, in the conversation, because I think that they're a part of our conversation and they do an excellent job in Wilco, and just wondered if that was part of the group that y'all are talking to.
Well, since CASA doesn't provide legal representation, we generally don't connect with them a whole lot. I mean, if we do collaborative stakeholder groups, we could certainly reach out to them. I do think on the pre-petition survey, I do think they were able to answer that survey if they wanted to, CASAs were. But since they don't provide legal representation, we don't do a ton of direct work with CASA.
I guess my thought is that they would have good input on how the whole thing works, and if I mean, a lot of the problems are the state, agency not providing the resources with the major turnover, in CPS. But I just didn't know. I mean, they would be possibly a good resource depending on what direction you're going. And anyway, just throwing that out.
Okay, thank you.
Okay, very good. I'm hearing no more comments. Justice Miskell for grants and reporting.
Okay, can you hear me now?
Yes. Yes, ma'am.
Okay. Well, I thought to welcome Jim aboard since he started yesterday. I thought I would turn it over to him to handle the grants. I'm just kidding, Jim. Welcome aboard. I don't know what the best way to handle this is since I'm remote. Do you want me to turn it over to Edwin and then I can call for the votes, or however would be the most efficient way to do it?
I'm happy to work through the agenda items, Justice Miskell, and then if you could just call the motions when it's time, I think that'll be probably best.
Okay.
So I'll go ahead and jump in. The first item on the agenda was an update on the Indigent Defense Expenditure Report. And unfortunately, we don't have any numbers to share with you. It's still in the very early stages of reviewing what has been submitted. We still have about 20 counties that still haven't finalized their report. This is the annual report that all of the auditors and some treasurers do for comprehensive spending on indigent defense. We're working with those counties that haven't gotten their data submitted yet, and we anticipate we're going to be jumping into desk reviews where a number of staff members will be vetting that information, and we'll have a comprehensive report at the spring meeting for you on where we stand with indigent defense expenditures in FY25. Next item on our section here is just a quick series of budget updates. So I'll just refer you all to pages 28, 29, and 30. Page 28 is just a status report on the revenue that flows into the Fair Defense account. And we try to monitor this pretty closely. And so what we're looking at the top of the page is just kind of for the period of September through November, how do we stand versus historical collections into the Fair Defense account, which provides a substantial amount, but not all of our funds. We do now have substantial general revenue funding TIDC, but the Fair Defense account revenue is an important piece. So essentially flat. You'll see that year to date, the collections for the state bar component of the Fair Defense Act collections is a little bit down for this 3-month period, but that fluctuates a little bit. So overall, last year we were up several $1 million in collections for 2025 over 2024, and this is kind of par for the course. It's essentially flat. So that's, I think, good news for us. We're still not expecting any juror pay. We used to collect some funds through the jury service fee, and that is no longer available for us. So that's all factored into our budgeting now. Page 29 just shows a update on obligations from previous budget years. We have some grants from FY24 and 25 that remain open. The biggest ones of those are related to Operation Lone Star grants that were in place, and we are in the process of closing out last biennium's accounting for those grants, and we'll be getting those off the ledger. And a handful of other grants where we've made extensions for various reasons because there was a delayed start often. But we'll be getting those larger items off of the previous budget year open obligations relatively soon as we close out the Operation Lone Star grants. And then page 30 is just a budget to actuals update. We're still early in the fiscal year. I apologize that the sheet is not landscaped. It's a little bit small, but we're just now getting underway with the grant spending for the year. We've made a few grant advances that the board has approved, but not much to report in terms of expenditures to date on our budget. There's a lag time as the counties submit their quarterly reports, and those numbers will grow, of course. There are no questions about the budget updates. We can move on to Doriana Torres, who can give us an update on formula grant matters. Doriana?
Thanks, Evan. I'm on page 31. We'll give a quick update on our Formula Grant Award for FY 2026. At our last meeting, at the August meeting, the board adopted the FY 2026 Formula Grant Request for Applications, RFA doc, with no changes to the formula and budgeted $20 million for the program. Formula Grant Awards are based on a combination of population and reported indigent defense expenditures, and our Formula Grant formula is on the page, right in the middle. Final award amounts will be determined upon completion of the desk reviews of the FY 2025 IDER. And if there are no questions, I can pass it over to Justice Miskell. We have motion number 2. Or Edwin.
So I'm happy to read the motion, Justice Miskell. There's a motion number 2 is to award $20 million in FY 2026 formula grants to counties according to the policy published in the FY 26 formula grant RFA.
All right, so moved, and we need a second on that one.
Second.
All in favor?
Aye.
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 And thanks, everyone. I am on page 32 now, where I'll give a quick update on our special conditions for formula grants. So as a quick reminder, when formula grants are awarded, special conditions are placed on awards to counties that are not in compliance with plan reporting and grant requirements. The status of special conditions for FY 2024. 4 counties have not submitted their OCA or Texas Judicial Council reporting. So that's Kinney, Matagorda, Terrell, and Tyler counties, and OCA staff and TIDC staff have been in communication with them. So we're hoping to close out that year soon. And the status of special conditions on FY 2025 formula grants. LaSalle has not submitted their IDER. 5 counties have not submitted their formula grant resolutions. Galveston County has not completed their approval process for ID plans or indigent defense plans, I'm sorry. And 47 counties are not in compliance with OCA and TJC reporting compliance. And our very preliminary status of special conditions for FY 2026. 20 counties have not submitted their IDERs. 72 counties have not submitted a formula grant resolution. 53 counties have not completed their approval process for the indigent defense plans. And 114 counties have not submitted or are not in compliance with court activity reporting requirements to the OCA or do not have an approved action plan in place. And as a reminder for FY 2026, these are very, very preliminary and these numbers are in line with previous years. And we expect these numbers to tumble quickly over the next couple of years as staff is in contact with everybody. Are there any questions? Great. All right, Evan.
Thank you, Doriana. I want to thank, I'm moving on to page 34, just wanted to give a summary of the TIDC Grants Reporting Committee meeting. I want to thank Justice Miskell, who chairs the Grants Reporting Committee, and Judge Woolley and Mr. Cohen, who's not here with us today, for their service at that meeting, which took place on December 1st via Zoom. We reviewed a number of grant requests that we'll touch on today, and we do have some committee motions that came out of that. So we'll get into the particular recommendations that the Grants Committee made, but we just summarized the activities here, and also wanted to note that in addition to developing some funding recommendations to the full board, we also did discuss and basically decided to bring forward to this meeting a request from Maverick County for some additional supplemental funds to get their regional public defender started. We'll get to that in just a few moments. And then we also had a good discussion about some possible policy alternatives related to how TIDC should respond when counties terminate a grant-funded program that is working as intended, and whether there should be any adverse consequences related to eligibility for future grants if they decide to do something like that. So we have another, we have a item later in the agenda where we can discuss that more fully. Anything else you'd like to add, Justice Miskell or Judge Woolley, about the committee meeting?
I did want to, because we are going to address a request from Maverick County, and I believe Crystal said Maverick County had not submitted their family, or somebody pointed out that this was the same county that has not submitted their family protection representation report. So I did want to make sure we flag that and discuss whether we want to make them do their report before we give them money when we get to that agenda item.
Yeah, so I think the issue with Maverick County's FPR report, and Crystal, correct me if I'm wrong, was that they did submit a report, and we had engaged with and these are reports from the auditor's office. The auditor is responsible for filing those IDR reports. there were efforts to kind of work through some of the complexities and make some corrections to the submitted data, and I think that was just never finalized. Is that fair? But it's a good point, Justice Miskell, and we can certainly make any decisions that might be made regarding Maverick County contingent on just kind of ironing out those pending reporting questions.
So is that Maverick's issue, or is that someone else's issue getting those numbers into us, Edwin?
That would be the Maverick County Auditor just needs to work with, in this case, Crystal on addressing some questions or corrections that were needed to finalize the family protection section of the IDER.
Okay.
Right, yeah, and I will just say, because when I create these data reports, at some point you want to close your data set, right? You don't want things to be changing, because then it's difficult to evaluate and create charts and graphs. So at some point I had to stop like working with the counties to get numbers in. We did go pretty late into the year this year to get all of these reports finalized. But I will say, yes, Maverick County did submit a report. So they are not the one county that didn't submit. They did submit. I just identified a potential, possible error. And so we've been doing a lot of back and forth, like, do you need to fix this? Do you not? And it just didn't get resolved by the time I needed to get this report finished up for all of y'all.
All right. Well, I don't want to stir up trouble where there isn't trouble, but I just thought it was worth a discussion.
Yeah, and we talked about the desk review of these IDERs. We really do put eyeballs in every single report, and there is a lot of follow-up with county auditors and treasurers to try to vet the data and correct things. So we can certainly circle back and get that addressed as part of any policy moving forward.
Well, I have nothing I want to add about our committee meeting on the 1st. So if you want to jump right into the agenda items from this meeting, please go ahead.
Thank you. So I guess the first item we will draw your attention to is page 35. We did get a request for a standard 4-year, what we call multi-year grant request for an indigent defense coordinator for Tom Green County. As you all know, the staff really recommends that every jurisdiction have an indigent defense coordinator, that point person who ensures compliance with Fair Defense Act requirements regarding requests for counsel, getting those requests processed and ruled upon in a timely manner, and appointments made in a timely manner. Tom Green County has identified the need for a dedicated staff person to ensure that all those things are happening as they should be. And so we do have a committee recommendation which is a committee motion number 3 to award Tom Green County an FY26 multi-year improvement grant of $44,019.
It's a committee motion, right? So you don't need a second. You can
That's
just
right.
call a vote.
Right.
Yep. So I will make that motion. All in favor?
Aye.
Aye.
Thank you all. The next item is regarding Maverick County's request for additional supplemental funding. And I should mention that we have, I believe, County Judge of Maverick County, Judge Ramsey English Cantu, who I believe is in the Zoom room, and we can go ahead and bring him in since the agenda item is up if he's on standby there. So just as a bit of background, and we're on page 36 of your meeting materials. Back at the June 2025 board meeting, TIDC awarded Maverick County a new sustainability grant to start a regional public defender office. And the program is to be operated by Texas Rio Grande Public Defender. They are a longtime collaborator and partner with TIDC. They've implemented a number of regional public defender offices in Texas. And so we believe that they are well suited to operate the regional public defender program under contract for Maverick Dimmidens of all the counties. So we have an award in place. Maverick County does have a history of policy monitoring findings that has been open for a number of years. I think there have been some very encouraging developments recently. One of those was the implementation of an indigent defense coordinator position in Maverick County that helps to ensure better compliance with the front end requirements of the Fair Defense Act and ensuring that requests for counsel are processed. TIDC provided a grant to Maverick for that indigent defense coordinator position, and it's been operating and is definitely an improvement. And then the fact that the county has stepped forward to request this public defender program, I think, is very positive development that indicates that while there have been a number of issues in the past, that the county is really interested in putting in place a good system that will be reliable and ensure compliance with all the statutes and requirements that are on the table. The county does have a very long history of very low spending on indigent defense. So even though our sustainability grant program, generally in the first year, the kind of standard is we'll fund 80%, the county funds 20%, and that levels off at a 2/3, 1/3 split. Because TIDC has some additional resources that the legislature has provided under the temporary assistance for rural defender programs, back at the August meeting, the board decided to reduce the required match for the counties participating in this program by 20%. So as it stands now, the award that's in place is funded 86% by TIDC and 14% by the remaining counties. But Maverick County, because of its long history of very low spending on indigent defense, is really struggling to come up with the match in this initial year. And I'm going to turn it over to Judge Cantu in just a moment. He can speak more from his perspective about that situation. The request that was submitted and Judge Cantu's letter is on page 37. Essentially is requesting that TIDC fund an additional $122,646 in the initial year. And that would be using some of the supplemental funds under the temporary or one-time assistance for rural programs that TIDC has. So it is something that would be part of this enhanced support that we're able to provide under that special legislative appropriation. It wouldn't be any kind of a new standard. It would definitely be part of this temporary program. And so the staff is recommending that the board consider approving this request because we think it's an incredible opportunity to help these jurisdictions really elevate the quality of the program that they're operating. If there are any questions about what I've said, I would suggest just turning it over to Judge Cantu, who can talk a little bit more about kind of where they are in Maverick and his request. Judge Cantu, are you there?
Yes. How are y'all? Good morning.
Good morning. Morning.
Well, first, I appreciate, of course, the opportunity to speak to y'all via Zoom, of course, today. I was actually scheduled to be in Austin today, but there were some changes over with the Texas Department of Agriculture, and unfortunately, couldn't make it over to y'all's meeting in person. However, I do appreciate, of course, the consideration that the commission is taking for Maverick County. I've taken note, course, of the other concerns that have been brought forth in reference to the auditors reporting on those other measures. And of course, I've already sent the necessary messaging over to our auditor to make sure that that is in compliance and to move that forward. But my concern, of course, comes to the commission today because of the simple reason that this year, Maverick County, by legislative action and through the legislature, was pretty much mandated what is the opening of a new county court at law. This is a completely new department for our county. Actually, starting today, the Commissioner's Court will have the opportunity to appoint a new judge to this court system. In moving this forward, of course, this is pretty much bringing quite a large undertaking of funding this fiscal year for the necessary needs of the respective newly created department and court. In this matter, this was, of course, a concern as not only as a judge, but of course, as the budget officer for the county, to make sure that this fiscal year, we could find, of course, that leeway to ask for the Indigent Defense Commission to consider what was an additional support for Maverick County in creating this program. Maverick County, as mentioned in your all's meeting throughout this morning, of course, has been going through a great transition. This is my third year serving as judge, but it's been an extreme commitment that I've had in order to make sure that the justice system and the ability to have counsel readily available for defense of those defendants that are coming before the court system is something that has completely changed from prior administrations. In this act, I think that right now where we are at is that I just need to make sure that we can provide the starting point for this public defender's office. Maverick County wants, of course, this public defender's office, and in sitting down with the defender's office, I think that we have been able to identify what is the necessary savings that would come into year 2 and year 3 that would be able to provide what is that necessary, pretty much that overage that would still be needed out of this year 1. And specifically from medical care, from our current inmates, finding, of course, those ways as to how we can supplement that and utilize that portion of the funding to create and to assure the additional funding for the Public Defender's Office in year 2 and 3. This is something that is extremely important, of course, not only to me, but of course to the district judges and to the court system itself. And, Maverick County remains, of course, committed to making sure that we can work this out as smoothly as possible, even with the additional new creation of a new county court at law. For that, I don't know if there's any specific questions. While we run on about a $29 million budget a year, this has been it's been a challenging year with a lot of specific need. There's been changes where we've had to even take from the district judges' budgets to modify, of course, the county court at law position, and also where we will be seeing some additional needs and findings and fundings from, of course, those indigent defense line items that are within their budget. So funding was coming along for the overall public defender's office, and I think that we will be in a position, of course, to be able to meet the needs at the requirements, of course, of TIDC.
I will mention that one of the things that Texas Rio Grande Public Defender, who's slated to contract and operate the program, has identified is that the jail population in Maverick is quite high, and they are very confident that they can reduce the jail population. I think, when there are beds opened up and available, of course, there's revenue opportunities for where the federal government will often rent those kinds of that kind of space when they have need. They often have need. So those are the kinds of, while he didn't get into the specifics, I think when Judge Cantu mentioned some of the savings that the county would be seeing and after the implementation of the public defender office, I think that's one of the types of things he's talking about is, people who are currently sitting in the jail could get out more quickly and their cases could be resolved more quickly, would have positive benefits that would assist the county in funding, future funding.
Yeah. If I might ask a question.
Yes, Judge.
What about the other 2 counties? What is their fiscal condition? You're going to be the fiscal agent as Maverick, but the other 2 counties, how are they fiscally? Your court of law is just for Maverick County, right?
Correct. Yes. And Dimmitt and Zavala County, of course, in speaking with both Judge Gonzalez and Judge Ponce, they're fully committed, of course, to the amounts that have been determined. Mind you, of course, Dimmitt County is only at 15% and Zavala County is at 10%. So theirs is a much lower amount. While Dimmitt and Zavala, of course, are in the oil and gas business and have a greater reserve fund than Maverick County does, that is, of course, not an issue that I do believe that should be a concern for the commission at this point.
One of the items that we discussed in our committee meeting on December 1st is, first of all, thank you so much, Judge English Cantu, for being here. I want to say we all believe that this is a worthy program for Maverick County. We're so glad to see the enthusiasm for participation. So there's no doubt about the sincerity or the appropriateness of the program itself. The committee felt that we wanted to make sure that this program is actually a benefit and not something that turns into a millstone. And so what we wanted to make sure of was the first year contribution of Maverick County has been reduced from the 80-20 that's standard down to, I believe Edwin said something like 7% at this point. And the committee was just conscious that we don't want that it's not a success if we're setting up Maverick County to fail one fiscal year later, right? And so we just wanted to make sure that we talk about this with the larger commission to make sure that this is truly a benefit to the program, to Maverick County, and that we're not setting up a program that is not sustainable the following fiscal year.
Correct. And yes, Justice, I know that in reference to that of course has been also a concern for me. I mean, as a budget officer for the county, I have to maintain, of course, that clearance of understanding the overall budget and the procedures that are coming for the next fiscal year. Mind you, as we begin planning for that new fiscal budget for the next fiscal year, this is already being taken into consideration in order to make sure that with those changes and those potential savings, as was mentioned by the chair, that the county should save and should see within these matters. I mean, we've had cases where we've had certain inmates that have been within the jail that have cost us, somewhere around $200,000 in medical expenses. So for those purposes, these would be ways for us to go ahead and make sure and find allocations of reallocating funding towards areas that are going to be keeping this moving and keeping the system moving. But more than anything, assuring that the district judges have the necessary legal assistance through attorneys, because that has been one of the greatest issues that we've had. We have one district judge, of course, who has one attorney who's on the wheel that does not have sufficient ability to move cases on his docket because there's not any attorney who is moving or who is wishing to serve on that court. And for us, it is important that, this office gets created, that there be the ability to move these cases. And from a financial and fiscal standpoint, we are taking the necessary stands already to prepare for the next fiscal year. I don't know if there's any other questions.
I do have one more question.
Yes.
Of course, we have our Hill Country Regional PDO, and each county's participation is based on cases, not on population. So how are you dividing your matchup?
I could probably speak to that better, Judge Evans. The budget that was prepared in conjunction with TRG, the Texas Rio Grande Public Defender that's going to operate the program, and they analyzed the number of indigent defense cases in recent years. So it is based on an estimate of the cases as opposed to population. And so the way that the three counties share of the operating cost was divided was based on an estimate of the caseload in each county.
And that includes OLS cases?
I'm sorry?
That includes OLS cases?
So the Operation Lone Star cases are funded separately. There are a number of cases in Maverick County that are OLS cases, and they fall under our separate grant that we have in place for everything OLS in those border counties. So this is basically the non-OLS sort of routine cases that Maverick County, this program would be stepping up to handle the standard caseload there, with OLS matters being handled under the other program.
Okay, so they were not included. OLS cases were not included in your percentage distribution.
That's right. They were looking at the other case, the sort of baseline caseload. That's right.
Okay.
Because all of our OLS cases currently go through the Lubbock Public Defender's Office, so that's how that's handled specifically.
Yeah, it's the Lone Star Defender Office receives a large grant from TIDC. It's actually been substantially reduced as Operation Lone Star cases have declined, but that fully funds all the counties that are impacted by OLS. The intent of the legislature was that those cases be covered in full. So that's happening under the other grant that TIDC specifically has dedicated for OLS. This would be for everything else, basically, the routine caseload in these counties.
So this was a staff recommendation. We talked about it in committee, and we felt the better thing to do was bring it to the whole commission. So would the appropriate thing to be to make the motion and then have more discussion? Or I'm not there in the room, so I can't get a sense of whether more discussion needs to be had.
Yeah, I'd like to say something before we go to the vote. Emily, please first, forgive me for my late arrival. I broke my ankle and I'm sort of trying to hobble around and deal with that. But I wanted to thank everybody for paying close attention to the situation in Maverick County. And in advance of the upcoming legislative session, I think it would be helpful to continue to pay attention to the situation. The challenge in Maverick County has been extreme, but it's not the only challenge that we're facing here. So whether it's Maverick County or anybody on this commission, I think as we come into the next legislative session, I'd like for us to focus on whatever we can do statewide to help with this situation. I'm more than happy to help in dealing with the legislature to make that happen. That's my only comment.
Okay, well then I will make a motion. Oh, go ahead.
I was just gonna ask, it sounds like there's a lot of different things happening here, and we're trying to help a county that is in need. So I appreciate that. And Judge, thank you for joining us today. I'm Valerie Covey, one of the county commissioners in Williamson County. So is there a way to not just wait a year and see how it goes, but actually stay with Maverick throughout this year and see on a basis that makes sense, monthly or quarterly or whatever, just to monitor and make sure, because none of us want to set you up for failure. And we can subsidize it up front, but then what? And so I appreciate you're trying to keep your budget going. It seems like there's a lot of issues, and we talked about the auditors getting reports in, and there's various things that we've mentioned about Maverick today. Want to help them. No, you don't have a lot of funds coming in, but you got a lot of issues. So maybe the agency can just work with them throughout the year to monitor and make sure that it's successful. That's all.
A great point, Commissioner Covey, and I can say that the county has been providing data that's in connection with our ongoing policy monitoring activities. So we are continuing, and I also mentioned that we implemented the Indigent Defense Coordinator grant. So we're getting reports and data associated on a quarterly basis, and I think maybe Joel might be getting information on a monthly basis. But I think it's a great point that we are continuing to monitor the situation. We have seen some substantial improvements in recent months. Really over the last year, I think things have seemed to get on track in a more positive direction. So point well taken, and it would be also part of our routine grant monitoring if the commission does approve the request to gather data, regular case flow data, and monitor the program as it's implemented. And then, of course, following up on the other requirements as well.
As part of that data we're collecting, are we getting the average time between incarceration and trial?
We certainly do. When we make an award for public defender, we do track those kinds of timelines. How long is it taking for the case to be processed and disposed? So that would be some of the core data that we will collect on the new program.
Judge Cantu, if you've added a county court at law judge, I think that's what you said, you're looking at misdemeanors. So, if your population is is heavy in your jail on misdemeanors, there's other ways of addressing that too, to help with I know we've had to do that too. And really focus on the felons in the jail, and as long as they're obviously safe and can get out and all that as well, keep their job so you don't have to pay for a lawyer. I know you're looking at all aspects to try to balance it out. So appreciate your efforts.
No, thank you, Commissioner. I know that's definitely something that we have been working on for some time. And like I said, the issue doesn't lie directly on concerns with misdemeanors. The issue right now that we have is on the felony side. Our district judges are the ones that are suffering to have the attorneys appointed, and there just are none who wish to work with the court system on the district court system side. I have 4 attorneys on the county court side that are on the wheel. Just 293rd has, I believe, 4 that are also on theirs. And then we have the 365th that has, I believe, 1 or 2 that are actually just on there, but it's a struggle. So the only way to actually do this, to get this moving forward, is for us to create this program, this office that will be able to move these cases and get people out of the jail system and go through the judicial system, if of course they're eligible to be released. So that's all. It's a whole process for us.
Well, and I was just looking at your total budget impact as you're trying to balance a lot of different things as the budget officer. So appreciate it.
Thank you.
All right, I welcome any further discussion. I'm going to go ahead and make the motion that is shown on page 36. Is that correct?
We have motion number 4, Justice Miskell, which I can read as the motion to increase Maverick County's FY 2026 grant award for the Tri-County Regional Public Defender Office by $122,646 to a revised award amount of $1,401,171.
And I also want to, so that's the motion. And I also want to clarify that the source of the funds is coming from a legislative one-time bucket for temporary assistance to rural counties. So that's we are directed to use those funds for that purpose. And this is one of the ways that we would propose to use that temporary fund set aside.
Noted and a very important point. Thank you, Justice Miskell.
Okay, is there a second to that motion?
Justice, I'll make that second. I'm sorry. Judge Shank, did you want to say something?
Yeah, I just wanted to get, did we get a clear answer? Somebody asked about tracking the data before the end of the next year. Did we get a clear answer on that? Is it yes?
We can, I think that Judge Cantu did note that he already communicated with the auditor to direct them to wrap up the pending issue. We could, if the committee wants to, yeah, so I think there's a commitment to address that pending issue on the family protection data.
Yeah, I just want to have I want to have data in hand before the pre-filing deadline in the next legislative session. As long as I have that, I'm fine with.
Okay, Judge Shank, Scott Ehlers here. I'm happy to meet with you separate and make sure that we collect whatever data you'd like before we move into next session.
Okay, perfect. Thank you.
So with that, I'll make that motion. I'll take the second on that motion, Justice Miskell.
Okay, is there any other further discussion, either Zoom people or live people, before we move to a vote?
Is this, Judge Cantu, are you still going to have court as well? Is this an additional court, or is this taking a caseload off of you as a constitutional court and moving it to a statutory court?
So I would still obviously have jurisdiction over the court system as well. Mainly, of course, my court systems will be, obviously my issues are more on probate, on guardianships, the matters, of course, that are ongoing, with a percentage as well of the criminal docket.
So it's taking a lot of load off of you on the criminal docket and put it on the New County Court.
Yes, sir. Yes. And it is also taken off of specifically the district courts as well, because there has been a percentage based on civil matters that have gone up to approximately, I believe it was 350,000 in civil matters that were pending. So there was a relief on the docket for the district court side on civil issues.
And you think that this money is going to, I mean, obviously it's going to help you with your budget and all. Is this, I guess what I'm getting, the sense I'm getting from you is that there's some kind of personal conflict between these district judges and the defense attorneys in the area, that they're not wanting to work for those district judges. How is extra money going to fix that?
Well, you see, with the creation, obviously, of the issue for the public defender's office, that obviously is creating the ability to have that direct defense counsel that would be readily available at the time of any individual that's going to be going through the jail system.
Okay.
So that defender will be obviously moving this case literally from point of arrest to point of indictment and moving forward. So it definitely will be an attorney that will be moving the case forward instead of having somebody sit in jail waiting to have that possible appointment within the necessary or within the allowable time frame to be detained. So
we're looking at not somebody on the wheel.
correct. This would be the public defender's office.
Yeah, these would be staff attorneys that would be operated by Texas Rio Grande Public Defender under a contract with the county.
Okay, Judge Misko, we have a motion, we have a second. Let's go ahead. If there's no additional comments, any additional comments? Okay, hearing none. All those in favor say aye.
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 Any opposed? Okay, passes unanimously.
Before we go on to the next one, first of all, Judge Schenk, I want to welcome you. I saw you pop on. You missed my opening statements from the chair report because I was, I also fell on Sunday and severely sprained my ankle, and I'm on crutches. I saw yours in the background, and so I'm severely on crutches too, and I've got a black and blue foot. So I tried to make up something like I was skydiving or something fun, and it was literally my foot fell asleep and I fell down on the ground. So I hope you have a better story. You're on mute.
Yes, so I was pulling stump with a long lever, and it turns out that the bottom of your body is part of that physics equation. So it went all the way over, it broke, and yeah, it swelled up like a grapefruit, and it's not fun.
I know, I agree. I think, did it happen on Sunday for you?
Yeah.
Yeah, mine too. It's 12:30 on Sunday afternoon. So now we're going to make it a new rule here that if you're going to miss any in-person TIDC meetings, you have to have severely either bruised or broken ankle.
I think any lower extremity might work.
There you go. All right. Well, thank you and welcome.
Thank you very much.
Yep. All right, Justice Miskell.
Okay, so I think we could probably let Judge English Cantu get back to his day. Is that right?
Yes, thank you, Justice. And once again to the commission, thank you all very much for your consideration here today. We truly appreciate it, and we look forward to working with you all.
Thank you.
Thanks for
Thank
joining
you.
us.
Thank you.
Thank you all. Okay, thank you. Thanks for that very good discussion. I appreciate it. If we can move on to page 38 in your meeting materials. This is something that we just ran out of time because the Grants Reporting Committee had a lot on the agenda and we didn't quite get to this one. So this is from Stevens County and it's a request for extraordinary disbursement grant. Just as a reminder, the extraordinary disbursement grant is a program set up for counties, mostly small rural counties, that have basically kind of a budget crisis as a result of a spike in unplanned spike in indigent defense expenses. And that's the request from Stevens County. The one thing that I want to highlight here that's a little unusual is that the Extraordinary Disbursement Grant Program works on a reimbursement basis. And usually we don't bring something forward for an award until after the county has dispersed the fund, incurred the expense and actually the money is out the door. In this case, Stevens County was very concerned about where they already stand with a group of 3 actually unrelated but very serious cases. So they have basically requested that we provide an up to extraordinary disbursement amount pending the receipt of documentation of the expenses. The district court has already approved, I believe it was $20,000 for expert witnesses in one or more of these cases that are still pending at this point. So we did do this similar situation for Stevens County previously back in 2019. The commission approved a similar kind of amount, provisionally approved it in advance, pending the submission of documentation of the actual expenditures. In that instance, we ended up dispersing $21,500. So that's kind of where we are. The cases are unrelated. They're cases that were not eligible for representation by the Regional Public Defender Office for capital cases. They weren't death penalty cases, but they were very serious felonies that involved substantial forensic issues and expert costs. And Stevens County, of course, is very small. I've noted their population is 9,106. Their total indigent defense expenditures for the entire year of 2024 was 91,000. So it gives you a sense of when this cluster of cases is on the horizon, they're very concerned about the budget impact and just being kind of waylaid by the costs here. So we do have a staff recommendation to award Stevens County an extraordinary disbursement grant of up to $20,000 pending receipt of documentation of eligible defense expenses in the cases identified in the county's application. Happy to answer any questions.
Edwin, are they participating in the Regional Public Defender Office?
Yes, they do participate in the Regional Public Defender Office, and they have since 2013 when they became eligible. As I mentioned, these cases aren't eligible for that because of they're not death cases, but they are very serious felons.
And then one follow-up, since we have budgeted 300,000, is this not one that we could potentially use the targeted specific, since it's a rural jurisdiction, rather than taking it from the extraordinary? It's not that much money, but that would leave the money in the regular account.
I think that's an excellent point, Mr. Bethke. I had not considered that because it came to us under the Extraordinary Disbursement Program, but I believe that there would be nothing to stop us from booking this under the Temporary Assistance for Rural Counties.
All right, I'll make the motion using the targeted specific fund or.
We would call it the Temporary Assistance for Rural Program.
Okay. Let's second that. Okay, any additional comments? Hearing none, all those in favor say aye.
Aye.
Any opposed? Okay, passes unanimously.
Thank you all. Page 39, we're not going to have a motion here because we haven't it's not quite right, but I did want to just give you an update on the request for extraordinary funds under our Operation Lone Star program from Uvalde County. We did receive a request for some of the Operation Lone Star cases that were not funded under our standard program to be reimbursed with OLS funds that we have available. I received a series of 3 large boxes with voluminous information that we just have not had a chance to go through. So I believe that what we're going to have to do is just put this out as an informational notice that we will in March be presenting to you a request for reimbursement of Operation Lone Star cases from Uvalde that were not funded under our other program. We do have the funds available with our Operation Lone Star dedicated budget, and it's just a matter of completing the review of the voluminous supporting documentation that was provided that we didn't have an opportunity to do. So I'll move on, unless there are any questions there, to page 40. So as you'll recall, and as we've discussed already in other contexts, we do have this appropriation from the legislature for one-time or temporary assistance for existing rural public defender programs. And we have a set of requests from the eligible programs for additional supplemental funds that are provided under that appropriation. When we issued the RFA, the request for applications for this special supplemental funding opportunity, we included several suggested types of uses for the funds, and one of the big ones was recruiting assistance. TIDC has created a number of programs, particularly in rural counties, where they have had great struggles to fill the attorney positions, particularly the felony qualified attorney positions. And so a lot of the requests have related to providing additional flexibility and funding to fill those positions that we've already created. So a lot of recruiting assistance is here, as well as internships or fellowships where we help to build the pipeline of new attorneys coming into indigent defense work. So you'll see a lot of the items are related to that. We do have, so the committee spent a lot of time going through what were voluminous itemized requests. You'll see on pages 41 through 43 a series of charts that show what the various eligible programs had requested, and then the rightmost column reflects the GNR committee's recommendations. And I believe we can take these up county by county. I do want to flag one change that occurred since the the Grants and Reporting Committee meeting, and that is on page 43. So on page 43, you'll see the request that we received from Texas Rio Grande Public Defender, who will be implementing the Maverick County program as we've discussed. We have positive recommendations here to provide them with some recruiting assistance in terms of signing bonuses, relocation expenses to get those positions filled, recruiting related travel, et cetera. The items in the recommended column on the right at the bottom, so these would be the last 6 items in the recommended column on page 43. Based on discussions with the committee and some of the members of the commission regarding that part of the request, I think the recommendation at this time has changed based on still believing that the program is not quite ripe for our funding. We made the recommendations pending receipt of the final documentation of judicial support. When we got that, once it was reviewed, it was apparent that while the judicial support was there to explore the concept of the diversion court program, because none of the details had been hammered out, it was that there was not a clear commitment to actually implementing the diversion court program. It was just exploring it. TIDC doesn't typically provide funding for counties to just explore a concept. We really want the plan to be developed. And so for the last 6 items in the recommended column on page 43, I believe the committee recommendation is to pull those back at this time and revisit them in March at the next commission meeting. Other than that, all of the Grants and Reporting Committee recommendations that occur in the rightmost column on pages 41 through 43 are intact and no changes. So happy to pause, ask if there's any questions about these items before we move forward.
I also wanted to note that one of the items for the capital case, let's see, that's on page
41. Page 41, the RPDO LGC is the Regional Public Defender Office for Capital Cases.
There we go. Okay. So at our last meeting, we had approved a pilot program for one of our counties to use a professional recruiter to see if that enabled them to fill longstanding vacant positions and to kind of write a report for us on what worked and what didn't. Given the capital case public defender's extremely long-standing inability to fill its positions, they requested money to participate with a professional recruiting firm, and we thought it was very appropriate to extend our pilot program to them as well, because those capital case defenders are notoriously have been objectively hard to fill those positions. And so we're not automatically approving those going forward, but as part of our pilot program, we really thought this was appropriate. So I will note that.
Thank you, Justice Miskell. Any other?
I don't know. On page 43, it says the applicant is Texas Rio Grande Public Defender.
Yeah.
And then it's the program, the BRPDO, and the Maverick RPDO. So
The award, the grant application comes from Texas Rio Grande Public Defender, which is a 501c3 nonprofit. They are eligible to receive a direct grant from us. Of course, we only would consider the grant if it was tied to operating a program in the county. And so to the extent that the commission would award this grant, it would benefit, particularly the recruiting assistance, would benefit both the Maverick RPDO and the Beeville Regional RPDO, both of which have vacancies that we're trying to help them fill.
okay.
But I just want to clarify, earlier you were talking about the diversion court component, and that would not be funded at this time?
That's correct. So if you look at page 43, the last 6 items are related to the proposed diversion court in Beeville. And because the judicial support was limited to just exploring the concept, we think it's not quite ripe. We'd like to bring it back at the next meeting. But that when we do get to the motion for this grant, to the extent that one is made, we would be modifying the motion to remove the items associated with the diversion court at this time. And with the anticipating that we'll be back in March with some of the details ironed out so that the judges can more fully express a commitment to implementing the program.
Okay.
So what's the amount gonna be?
The amount for TRG, the Texas Rio Grande Public Defender, that is currently showing as 493,168 on page 43 would be changed to 272,319, which would just be the recommended items on the top half of page 43 and eliminating the bottom 6 items on page 43. So that would involve modifying, if you have a motion sheet, we would modify motion number 10 to the extent someone makes it, to change the Texas Rio Grande Public Defender grant to reduce it from 493,168 down to 272,319.
I'll make that motion.
I'll second it the way that it was amended and read by Edwin.
Okay, so this is specifically number 10. You're moving to or there's no second because this is a committee motion, right?
Well, because it's being modified, Justice
Got it.
Miskell, I think we need a second. It's not a committee motion because it's changed.
Got it. Okay. All right. So we're making the motion just on item number 10 at this point, minus the diversion court expenses that have been subtracted out per Edwin's math.
Voting on these individually or is this
Each grant. Each grant. So it's for right now, the motion that's been made is related to page 43, the request from Texas Rio Grande Public Defender. And I believe the motion that's been made is to award them a temporary assistance rural programs grant of 272,319 for the items on the top, recommended items on the top half of page 43.
Okay, and I think I made that motion and Judge Maderi seconded it. Any questions, comments? Okay, hearing none. All those in favor say aye.
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 Any opposed? Passes unanimously.
Thank you all. We'll backtrack a little bit back to page 41 and we'll just take up the remainder of these program by program.
So Edwin, can I move 6 through 9 and 11, or do we need to go one by one?
I think you can certainly make a combined motion, Justice Miskell.
Okay, so I will move the committee motions identified on our list as 6 through 9 and 11 for approval by the commission. Any discussion? All in favor?
I'll second
Aye.
Anna.
Aye.
Aye.
Aye. All right, thank you all. The committee did a lot of work and you can see that there were a number of requests that we just didn't think, if you look at the itemized list, there were some things that we just didn't think fit with our program or were just something that we could not fund. So I want to thank the committee again for all the work and helping us to sift through a lot of requests and really bring forward to you these ones, which we feel very positive about will make a great difference. We're making good progress. I appreciate your patience. Let's move on to page 44 in your materials. And this is regarding a potential policy consideration, potential new policies regarding grant eligibility for a county that might terminate a funded program. So the committee did begin a discussion about this and develop some thoughts. But just to kind of summarize the issue that we'd like your input on, since the beginning, TIDC has always been focused on using our grants to implement permanent changes, permanent improvements in Texas indigent defense. And our standard grant is 80% in year one. It kind of steps down over the next 3 years, 60%, 40, 20. And then we expect the counties to step up. And the idea is to provide incentives for counties to implement change, to implement positive new improvements. But that ultimately in our standard program, the county is committed to picking up the funding moving forward. Of course, our sustainability grant program, we provide 8% in the initial year, but then we move on to an ongoing commitment to fund 2/3 of those sustainability grant programs for rural regional public defender offices. And the idea is to, again, if a program is operating as intended and if it's successful, we are banking on continued commitment from the local jurisdictions to continue programs that are operating as intended and are successful. So we're looking at permanent changes. Now, this is obviously kind of complicated by the fact that we've got this special legislative appropriation for some temporary help. But that's definitely non-standard for us, and we're happy to provide that temporary assistance when we can. But it's kind of outside of our core commitment to implementing permanent changes. So we think that it may be appropriate to strengthen and formalize the jurisdiction's commitment to continue programs and not just draw down grant funds when they're available and then just dump the program after they have to start paying for it or what have you, for a couple of reasons. We don't want counties to accept grants and then terminate them when state grant funds start to wane. And we want to avoid regional programs where a host or participating county pulls out of a successful regional program and destabilizes that regional collaboration that is otherwise might be working well. So at the bottom of page 44, staff just developed at a high level some policy ideas that the commission might want to consider regarding strengthening the commitment to, or at least developing some kind of negative consequences or negative incentives to deterrence, I guess is the word I'm looking for, to taking one of those kinds of actions. We could do something like bar eligibility for future grants for some period of time. 3 or 4 years was mentioned in some conversations. If a county terminated a program without good cause as determined by the commission. We could add language to the commissioner's court resolution that required expressing a clear intent to continue successful programs. I will mention, and our county judges will probably, and commissioners will probably note that a particular county commissioner's court cannot bind the budgets of future county commissioners' courts. So that's obviously something that would not be an avenue for us. However, we could ask for a stronger good faith commitment, a more explicit good faith commitment to continue. We could consider suspending formula grant funding for some period if a county terminated a program without good cause. We could also require some kind of repayment of the grant funds distributed if a program is terminated without good cause.
Is there going to be a motion, or is this just under advisement for like a future meeting?
This would be, the intent is to get some guidance from the members about the policy direction, and we'd like to get your guidance and then come back in March with a more fully developed program. We'd also like to get some guidance on the kind of language we should include in the request for applications that we're going to be issuing in January for the next grant cycle on this matter.
And if you, Bill, could you possibly come up with something that's kind of succinct so we can vote on it?
Some of what
So
I
let
believe.
me, sorry, I was going to say what we discussed in our committee meeting. The purpose of this, when we inquired, like, why is this coming before us now? What is the reason for considering it? And the answer was, in the past, when one county pulls out of a multi-county program, the multi-county program is destabilized. It has outsized impacts on other counties that are not fully priced in to the county that pulled out's decision. And so really, when we got down to it, this is an effort to price in the externalities and make sure that a county considering pulling out has to consider the wider impact beyond just their own county. So these aren't punitive in nature. It's not, you don't want to work with us, we're taking our ball and going home. This is truly because one county's action can destabilize a larger region. And we want to make sure they consider that there are costs to pulling out of a stable program. Did I restate that fairly, Edwin?
I think that's the great synopsis, Justice Smith.
So the language that we had suggested in committee was, for now, not to decide which of these options or other options that we are actually going to go with, but just to put some kind of statement in the RFA materials that early termination of a program may affect eligibility for future grants or may incur repayment costs, and not really go beyond that, but just alert them that that's a possibility. And then after our March meeting, we could flesh out what the commission actually wants to consider.
And I want to add to what Justice Miskell said too. One of the things we did discuss in the meeting as well was if a county grows to where they need their own PDO as opposed to being a part of a regional, we obviously wouldn't, that would not affect that part of it.
Right.
Well,
So
and let me also, well, go ahead. I'm sorry.
Go ahead, Judge. Go ahead.
Well, and the other thing I would like to say is this, there have, been rumblings that, there are different counties around the state that, have been kind of, I guess, rumbling that, well, we can accept 2 or 3 of their years, and when it gets up to be higher, we don't have to go forward anymore. And so, they're taking the fat end on the front of it, and then saying, well, we can always just get out of it. Now, we always realize that there's going to be, and that's why when I spoke with the staff too, that there's going to be good cause for something, right? And so not to make it end all be all, like if something happens, you're not getting, we are taking our ball and you are not going to be playing with us for 4 years. And so we don't want to make it all end all be all, because we understand it can't be a hard and fast policy. But I do think that it has to be, because I've heard it from a lot of different counties, right? Where they say, well, we'll just take the first couple of years, and then we can just, so everything we've put into it, now all of a sudden it gets to you got to pay 40%, and they go, no, we're not doing it. And so we want to make sure that, one, that they have an interest in continuing, but also realize that, if they're not going to do this, then there's another county that might need our help and our funding. And so we want to make sure that when they apply for these grants, that they understand that it is a partnership, and that we're helping them out on the front end. And, we hope it's going to be an awesome program. It's the only reason we do it. And then hopefully, they continue on. So that's my 2 cents on it when Jim and Edwin and Scott and I met as well. And that you all had talked about it, Emily, in your meeting as well. So that's my 2 thoughts.
And Judge, I agree with you. I think we're all in favor of regional and collaboration, especially for the smaller counties that have a hard time making ends meet on their own. It's almost, and I know I've got a lot of lawyers in the room, but it's almost like a contractual situation. We're committing, the TIDC is committing funds to accomplish a goal, and they on the other side should be committing funds too on the other end. So it's not just something that we spend the money up front. And sometimes when we've had contracts at the county, we've and somebody's spent money on something, if we're going to take it back, they have to, there's a pro rata obligation there to reimburse. And I don't know how we do that exactly, but you've put the words in there, Judge, to indicate that there would be possibly some of that. But I think we really do need to flesh that out, because there's not enough money to go around, and it's not right for a county to go into a contractual obligation knowing they're going to pull out, or thinking that they're going to pull out before it gets hard. And we need to vet them up front to say, if you can't hang with this for the whole total, years and your obligation, then maybe you're not ready to start this. So I don't know, a lot more discussion to be had. Appreciate it.
And I think that staff needs to go back with this direction, right? And kind of seeing where the commission is standing on this, and redo these words to see, what we want to vote in March. And I think you've kind of got the opinions of the commission now, and see where we go from here, and then bring it back up in March.
I think the one thing we did have to decide today was, do we want them to go ahead in the RFA materials to warn people that this might be coming, in not necessarily specific language, but just early termination may negatively affect you.
Yeah, Judge Shank, I saw your mic
it
on.
seems to me there's like at least 3 pieces of this. One is, would we want to vet them? I think everyone would say yes to that, to see if they're likely to sustain through the program. But separately, whether we could claw money back, that seems like a different leg. And then Emily's main point, I think I agree with. Do we want to signal to them that there will be some consequences in terms of their relationship with the commission if they terminate early? I think the answer to that is yes. But the question to me for the staff to work out is, would that be automatic, or would it be just sort of discretionary? And if it's automatic, how long of a period would we talk about? I might lean towards it. It would presumably be automatic subject to, for some period, subject to a good cause motion to, or basis for relief, because you will have circumstances where the personnel in the county will change either by an election or something else. And that would have been the cause of the problem in the first place. We wouldn't want to anchor ourselves into a position where we couldn't go backwards because some person or a group of persons who are no longer there presented the problem. So I'd be inclined towards at least answering Emily's question of, do we want to signal with a yes? And then anything will work, but I would be inclined towards something that's automatic but subject to reconsideration on approach to the commission.
Thank you, Judge Shank.
While trying to be concise and also reflecting an important consideration from GNR with the discussion on the reason for this, so that it's also clear that this isn't just we're trying to put strings on county. Something along the lines we had talked about was recognizing the significant investment of public funds as well as potential effects on other counties participating in regional programs. Counties terminating a grant-funded program may be ineligible for future TIDC grant funding and/or repayment of of expended grant funds, at least for the RFA, and then we can look at more specific language for March.
I think the question for March, which Emily was begging, is would the word be will or may, right?
I recommend will.
Yeah. But I don't think we have to decide that today, but I think something, the may for now, because it works just in terms of notice.
Yeah, I think our plan would be that we'd be back to you at our next meeting with detailed policy options. You would make some decisions, and then we would communicate that clearly to everybody in advance of any approval of new grants in June as part of our regular cycle. So I think as long as we have some kind of notice in there that there would be adverse consequences, and then we'll disseminate the details of any new policy in March, we accomplish the goals that you all have been discussing.
So, Evan, comment from somebody who's done 30 county budgets. Whenever, when you come back to the commissioner's court and say you're going to have to repay, okay, that is not going to be in the approved budget. So what we declared emergency and have to repay, I think that becomes an issue. There, I think maybe to be rather than repayment, I think you can punish going forward, but repayment I think is going to be a real problem. Yeah, in my opinion, because if it's not in the budget, we have to declare an emergency.
So are we going to go to court? Are we going to sue them?
No.
Do we have authority for that?
I think the
that's part of the deterrence, though, right, Judge? I mean, if you're gonna ask for this money, and you're thinking that you're going to put it in your budget for those 3 or 4 years, and then your intent is to drop it off, then you're going to.
I think the will in the first part of your comment would work, that you will be removed from future programs subject to a good cause shown to the commission later, and then may is a good way to say, and may be subject to a repayment requirement. It gets the deterrent point across, and we don't have to go to the moral hazard question of when and whether we're actually going to try to profit the money out of them. But it's kind of like telling Virginia, if you're going to try to secede from the union after you've taken the highway funds, we may send troops, but maybe.
Well, I didn't know we had troops. That's kind of fun.
I think that
we have Joel.
There you go.
The proposal that
there's a lot of judges in the state that are scared of him.
We can say will adversely affect prospects for future grant eligibility and may involve repayment. Obviously, any adverse consequences that would befall a county would be reviewable by the commission. We would never make such decisions at the staff level. So the commission would ultimately decide whether a good cause was present for such a termination. So I think we'll be very careful in how we communicate that both of those would be part of the policy that we will bring back to you. But
Excellent discussion.
I think we have to be very aware that Senator Betancourt and some other people in Austin want to curtail county's ability to raise any money. You know, we have a zero increase or 2 or 1%, and that there may be circumstances if you have an emergency in your county that your funding is going to be absent. So I think we have to remember that. We're at the pleasure of the legislature or displeasure of the legislature on the county side. So I just want to make sure we understand that.
Yeah, and Judge, I appreciate that. I think that you know, if the county decides to opt out in year 3 or 4, let's say when the money starts getting more for them, then in that year's budget they could plan for that. It wouldn't be that they would have to go back and do it again, you know, for I mean, they could plan for it then, but that's part of their decision to opt out. And, you know, nobody knows what the future holds for any of our budgets. Obviously, we've seen some radical changes lately, but I think that, you know, we've got to have some consequences so that we discourage people from just taking the money and running. And so however we need to work it, and I'm sure that there'll be perfect words for that, you know, as we go forward. But anyway, I think we're all on the same page.
That's what I was going to suggest. We need to study before March because, you know, government spending is a different animal. And maybe if repayment is not something that's allowed, maybe it could be phrased as you're still obligated to make your scheduled payments, right? So I don't know. We can look into the technicalities of everything before March, but I don't know if there was a motion or not, but the sense I got from the room was that language for the RFAs is acceptable to the people who have spoken so far.
yes, I really appreciate the discussion. There's a lot here. We will come back to you with much more research and detailed proposals for your consideration at our next meeting. I do think we have consensus on the kind of put them on notice language to include in the RFA based on the discussion today, which has been very helpful. So I would suggest that we just move on to page 45, where we do have a motion to publish the 2027 improvement grant request for applications with changes, non-substantive changes, and then with the notice included with high-level language as discussed today about possible adverse consequences under the circumstances we've been considering. And that is motion number 12.
So moved.
Second.
Okay, this discussion. So what is the high level language you're going to insert?
Go ahead and read it, Bill.
Recognizing the significant investment of public funds as well as potential effects on other counties participating in regional programs, a county which terminates a grant-funded program may become ineligible for future will become ineligible for future TIDC grant funding and may be subject to repaying expended grant funds.
Well, I got what David was saying on the first one being a will. I think that should still, I think we need to make that a may in the RFA. Because we may allow them to do it in the future, especially if they're getting out of that to do their own. I mean, we're not going to say, no, we're not going to give you any money because now you're creating your own PDO in your county because you've grown so much. I think they should both say may.
Something about just cause. I mean, there may be a reason that's legitimate.
So I think we can add the termination of a funded program for just cause as determined by the commission. And or without just causes, good causes determined by the commission. I think you know, your point, Judge Woolley, is well taken, and by using may in both cases, you know, we talked about the way the initial draft, it sounds like it's forever. If you have a whole new cast of characters in a jurisdiction, you want to be able to reconsider it. So I think based on that amendment, making both clauses preceded by a may, adding the good cause language, I think that captures the consensus.
Good, and we have a motion, we have a second. Any additional comments?
What is the language now?
Jesus.
Recognizing the significant investment of public funds as well as potential effects on other counties participating in regional programs. A county which terminates a grant-funded program without good causes determined by the commission may be ineligible for future TIDC grant funding and may be required to repay expended grant funds.
Excellent. Any additional comments or questions? Okay, hearing none. All those in favor say aye.
Aye.
Any opposed?
Aye.
And just to be clear, that was the whole motion 12, not just a vote on that particular language.
Yes. Thank you all for very helpful discussion. We've got good guidance. We'll be back with this next time, but I really appreciate the feedback and guidance. Thank you very much. We can move on to the fiscal monitoring report beginning on page 46.
Good morning. Pages 46 to 52, you'll find the fiscal report. Just to quickly report, since the August meeting, the fiscal team went on one on-site monitoring trip. That was to both Uvalde and Kenny counties. This was in conjunction with the policy team's visit out there as well. We also issued 2 initial fiscal reports. They went to Potter and Randall counties. A joint presentation with the policy team because they sent their report out at that time as well. We made a presentation on all the findings to Potter County. Both those counties have submitted the corrective action plan for the fiscal findings. And since this report was generated, the final reports went out for both Potter and Randall counties. Next, we have the improvement team, improvement grant reviews. We had 7 counties that had improvement grants reviewed in this period. There were no issues noted on those. And just to let you know, like a lot of our time in October was spent on helping auditors and treasurers from around the state get their IDERs submitted and hopefully timely, but there are still a few out there, but we keep helping and we're glad to do it. And lastly, I just want to mention that I had 1 county, it was Hidalgo County, that submitted their comprehensive annual financial report and single audit. They did not have their TIDC grants selected as the major program. So nothing really to note there. And that's it. We can go on to improvement grant, I think.
The team.
With the late hour, just to highlight a couple of things. Planning studies, we have had a number of conversations with counties who have expressed interest in starting either a county or a regional program and have sent planning study request forms to them and anticipate hearing back in the next few months on them. We also had an intensive discussion about planning studies at the Indigent Defense Workshop and got a lot of questions and good feedback from it. One item we are working on as we continue to look at revamping and improving planning studies is developing a new module to assist counties that have programs which do not currently deal with capital murder cases to look at what they would need if they were to start handling non-death capital cases, otherwise known as the LWOPs or mini-cap cases, for what their staffing would need to look like so that they can begin conversations with their counties to see if it might be a solution to fit their needs. We also continue to work on providing technical assistance. As was mentioned earlier, the stakeholder manual, which is the first part of our Chiefs Toolbox series, is out and on our website. Ashley De La Garza is leading the work on our Chiefs manual, which our chiefs have described as everything I wish somebody told me before I got this job. To highlight some of our ongoing technical assistance, I've been working very closely with Polk County and Wharton Matagorda, which are 2 of the new offices the board funded this summer. Wharton Matagorda has posted for their chief. The postings closed on Wednesday, so hopefully there will be a good candidate pool. They are moving very quickly to get the office up and running and are hoping to get interviews done either this month or in January, depending on the candidate pool. Also, our Future Indigent Defense Leader 6th class applications have closed. We'll be holding interviews next week, and that class will have their intensive training taking place in Austin this April. I'm not gonna go through the list of trainings and committee work we do on an ongoing basis. However, I would like to have Ashley De La Garza, who has done a significant amount of the lift for our recruitment work this fall, do the recruitment update.
Yeah, so we stayed busy this fall in not only tabling and attending several trainings, but also continuing our public defense day. So thank you to Cody Huffman, Kenitra Brown, who's not here, and of course, Kristen Meeks for doing that. We were able to partner with several law schools and career services and student organizations. And for this fall, we covered 5 law schools with over 155 students that we interacted with. And of course, we had 11 defense organization and 13 different attorneys that helped us do these panels. We continue to do programming for the spring. We have several other law schools we hope to hit, but I think students are engaged. We are also really highlighting our public defense job board, which I think is very helpful because they now have all the jobs listed in one area, which they all tend to enjoy being able to go and look at. So yeah, thank you to our team and we'll continue the good work.
Okay, policies and standard, Alex.
We're running late. I'm gonna be very quick. Page 59. As you already heard from Gloriana, we have 53 counties outstanding on their indigent defense plan submission and approval process. At the time that they were due, we had 164 counties that had submitted. That's in line with past years. So we've sent reminders early this week, and we've actually already had a number of judges approve their plans. We'll begin reviewing those in the new year. In particular, the 2 new items that the board required that they address capital case appointment processes, which some of the plans don't currently. And then in counties with short-term contract systems of 1 week or less, that they include caseload limits, annual caseload limits. So we'll be looking for that. The next item is potential TIDC policy monitoring of the new bail policies that Scott mentioned. We're exploring that. The 2 main things that we're going to be looking at is in the constitutional amendment that there is a specific provision that the defendant is entitled to be represented by counsel in those cases where the prosecutor is seeking to deny bail. And then in the appeals process where the prosecutor can appeal to the Intermediate Court of Appeals, we'll be monitoring the Supreme Court and the final rules that may be adopted to implement that proposal. In the meantime, staff is part of our policy monitoring, and we're out a lot this fall. We have 2 teams that are going to be in the field next week. We'll be asking questions about how are they implementing these new provisions. If there's any challenges, if they need any further guidance, and then ultimately we'll develop recommendations to bring back to the Policies and Standards Committee and ultimately the full board, potentially with some rule amendments to incorporate a review of these new policies.
Good. Thank you, Phil. All right, for a summary of recent policy monitoring activity, please turn to page 64. Since our last board meeting in August, we've issued 7 policy monitoring reports. Those were to Potter, Milam, Williamson, and Starr counties. I want to highlight Williamson County. Williamson County did a great job of addressing our past findings, and we're closing the review. So I just congratulate Williamson County for its great work. We've received responses to monitoring reports from 4 counties, and that was Galveston, Randall, Taylor, and Tom Green counties. I want to highlight Tom Green County because they had issues with misdemeanor or timeliness of appointment. And to address this, they applied to TIDC for an indigent defense coordinator grant. And you just approved that application today. And so I think this is going to have a great impact on the county. Finally, turning to pages 68 and 69, we have a summary of recent data reports from Maverick and Zavala counties. As a result of some longstanding monitoring reviews that we couldn't address the findings for, we require monthly data reports about the number of counsel requests that each of these counties get and whether they appoint counsel or deny indigents. Maverick County recently approved or has put in place an indigent defense coordinator position. And I think that's greatly helped the appointment process. The one issue they had was having available attorneys to appoint. And I think with this new public defender office, this should address that issue. And with that, I would like to turn this over to complaints.
Hi, everyone. As usual with complaints, I'm going to submit on the record. But because this is the season to think about why we're all here, why this commission was created, I have included excerpts from complaints that were meritorious within scope and were shared with officials that are from defendants or defendants' family members. And I would like to highlight for y'all on page 72, first page of the report is on page 71. From Hunt, there's a lack of communication with defendants, some of whom have been held for over 4 months on misdemeanor charges without updates or advocacy. She, the attorney, often delegates messages to her clerk citing delays in prosecution offers rather than actively pursuing her client's defense. This approach raises concerns about inadequate legal representation, potentially undermining her client's rights and shifting the balance of justice prosecution. At the bottom of the page from Lamar, the last sentence, because this gets at the gist of it. What is the point in having an attorney if they are not going to do anything and then having to pay for them? So thank you all. I would encourage you to read the excerpts. I believe the numbers speak for themselves.
Okay, thank you. We do have next meeting in previous conversations. I think we're going to try to coordinate it same week as Texas Judicial Council. That hasn't been set yet. So I think the next meeting will be late March, early April. Any new business?
I had something I want to mention. So Alex Bunnan, who has served the commission for many years now, since 2017, he is retiring as the chief public defender imminently. I guess you're the emeritus right now, correct?
I'm still a public defender till the end of the month.
So what this means is that Alex will be rolling off the board. He will be here until the governor appoints a new chief public defender to serve on the commission. But I wanted to thank Alex for his service to the commission, but I also wanted to let the members know that this is happening, that we will be searching for a new chief defender to be on the commission. If you have someone in mind, I would encourage them to submit an application to the governor's office to be considered to be appointed to the commission. We'll also be needing a new policies and standards chair. If anyone would like to raise their hand and volunteer that, or maybe Judge Madera and tell somebody for the job. But nonetheless, thank you, Alex. I don't know if you have any parting words of wisdom. If it is parting, he may be back in March or April.
I did get an email from the appointments office asking about my situation. I said I was coming to this meeting, and after that, you can do whatever you need to do. So they may be acting soon.
I'd like to also say, I mean, Alex, I came on, I think right after you came on. I've been on, oh gosh, next year will be 10 years for me. And, I do understand how much work it is to be on this. And you have just been, somebody that I've looked up to and somebody that I've looked to for advice. So I just want to say, on behalf of all of TIDC, we're very, very thankful for your service on the board. You will be missed. I'm going to call the governor's office, tell them not to reappoint and put anybody else in there. So you'll just be a holdover for like 4 or 5 years. Anyway, Alex, thank you. And in regards to policies and standards, if anybody wants to be considered for that, please reach out to me or to Scott. And then, we can volunteer or we can voluntold. And so hopefully somebody will want to take over and fill Alex's shoes on that. But on behalf of the commission, Alex, and thank you for your service and thank you for your friendship.
Yes. And Judge, just real quickly, the work TIDC, fantastic, but even more significantly, what you did with the Public Defender Office in Harris County, which is tough waters to navigate. You've set up an outstanding program. The transition to the new chief has gone swimmingly smooth. You've expanded that office significantly. So I want to thank you for, from really soup to nuts, setting up that program and setting it up excellently.
Thank you, Jim.
You can go into the Capital gift shop and get yourself a keychain too.
You get a tie there one.
Yeah. All right. Any public comment? None.
As for the policy committee thing, I think I saw David raising his hand when we were. He went to scratch his head and his hand came down really quick.
Motion to adjourn?
So moved.
All right.
Second that.
Thank you. Be safe.
All right, bye, everybody.